I thank the chair. And first of all, I don't like the term patent trolls. These aren't patent trolls. They're patent bullies. Like the bully on the playground in 3rd grade, the bully every Monday comes to school, threatens to beat you up if you don't give him his lunch money. These are patent bullies. And thinking out of the box on how we stop this behavior, in my home state of Texas, again, not directly applicable, but they did something in 2011 called basically loser pay. My state senator, Joan Huffman, got that thing passed. It's been going on for about 3 years now. And what they've done, not so much in patent protection, but just sort of legal protections for some of these frivolous lawsuits, they basically empowered the trial judge to say, this is garbage. Throw it out. He gets the initial filing, say, frivolous, done. If that doesn't work, okay, how about I send it up to if they're going for the home run? We know it's really bad, but we want to take that shot, maybe knock that thing out of the park. And that's the case, I can send it straight from my court to the appellate court, get this taken care of quickly. So again, the aggrieved party is not paying legal bills on and on and on. Also for the small guys, if it's less than $10,000 or $100,000, expedited civil action procedure. And so I ask all the panelists, is that something we should look at? I mean, I know there's lots of pros and cons, more federal involvement, preemption, that type of stuff. But again, how can we take this hammer away from these patent bullies? It's not patent trolls.
If you don't mind, I'll take the first shot at it. I certainly believe that part of the legislation should include some opportunity for the party that's been aggrieved in this situation to have their costs reimbursed. I suspect if I got a letter from Caterpillar, I'd pay attention. But when I get a letter from an entity I don't know that just lists a whole bunch of numbers, clearly for someone like us or any small business to defend, we've been told it's $1 million cost to defend a patent lawsuit. We're certainly not in a position to do that. And I really do believe that if a patent troll or a patent bully ran the risk of having to reimburse someone, they'd think twice about doing it in the first place.
General Stroll, any comments, sir? And my parents are voters in Vermont.
In the Vermont statute, it allows for awarding of attorney's fees, but again, to recover, you have to establish that there was a bad faith assertion of patent infringement. And I think some of the concern about AGs getting involved in this arena is, are we going to sort of muddy the waters? Speaking for myself and pretty comfortably for the rest of the AGs, we do not want to try to get in the middle of a fair fight between two companies where it's a reasonable fight as to whether this patent exists and what it controls. We're really trying to deal with the bottom feeders, and we think that there should be the current federal standard of the awarding of fees in patent cases ought to be eased so that they're awarded more frequently. I'm not prepared to say that loser pays in every case. That might be an overreach there.
Mr. Scarvin?
Well, I would just say that some of these concepts, I think they can work conceptually. Generally, they fall down if you try to apply them just to one side of the coin, so to speak. They have to be available, similar to bonding, to both parties, because you're predetermining that somebody actually is the bully ahead of time. It all comes down to what actually is going on. Certainly wouldn't want to be one-sided and attach that type of penalty to a legitimate patent communication.
Yeah, it sounds like the bully becomes the bully, maybe, in that situation. Professor Schultz, any comments, sir?
Yeah, so I do think that, many of the efforts that are being explored in Congress right now, I think, are comprehensively looking at the problem, and I think that linking them together and making sure they all fit well together is good. So I think that, for instance, the type of demand letter or the kind of information that is or is not shared and how vague and how deceptive it is may well be appropriate factors to play into a fee award, right? Or to, say, an adjustment of whether damages are available for willful infringement or not. These kind of things, I think, are linked and are important. But I do think that it needs to be dealt with, the whole problem needs to be dealt with on a couple different levels. Okay. Mr. Chan, run out of time, sir. You got one more swing, take it out of the park?
The Innovation Act that passed the House with overwhelming bipartisan support includes a provision for some cost bearing when a case is completely unreasonable. In this particular type of problem that we're talking about today, though, it's unclear how that plays out because these things don't generally go to litigation, because they get settled because you have someone who's using Wi-Fi in their business that is told you can spend hundreds of thousands or millions of dollars to defend this, or you can just pay us $2,000. So
Yeah,
I
the
think
bully.
the promise of that might be illusory, and we just need to, I don't call them trolls because I don't like to demonize my adversaries. I would just say they're like rats running through a maze, and we need to take the food away at the end, and then they will stop going through the maze. And that's a systemic issue that we can address that won't result in a lot of litigation and awards at the end of it.
Thank you. About time, Mr. Dixon, very briefly, sir. If the chair
Thank
with his
you,
indulgence.
Mr. Olson. Now